I'm Drew Stevenson, and this is a lecture about the case Smiley versus Citibank, a U.S. Supreme Court case from 1996. This is a case that talks about the problem of preemption, federal law preempting state law, and Chevron deference, or judicial deference to administrative agencies when they're interpreting statutes. For my students, we're going to talk about preemption in a different part of the course, and it's a complicated area. The Supreme Court has spelled out different types of preemption, and honestly, there's a lot of uncertainty in this area. The cases are a little bit all over the place. So we can talk about preemption in the classroom, but what's going to happen in your case when you're in practice, there's a lot of uncertainty about. And that complicates things because we have supposedly a presumption against preemption when in statutory interpretation. And then we also have a presumption of judicial deference to agency interpretations of their statutes. And that may work pretty well most of the time when we're talking about an unclear term in the statute and the agency, or the statute is silent and the agency has to sort of fill in the gaps in order to implement the statute as Congress has instructed them to do. The more complicated question is, what happens when the agency's interpretation of the statute is what is preempting state law? And the court here weighs in on this, but it's still sort of an open question. So let's look at what happens in Smiley versus Citibank. Also, I need to say at the outset that the agency that in question here is the Office of the Comptroller of the Currency. We'll talk about that in a moment. And it's actually not a party in the case. And this can be a confusing thing for students who are really like paying attention to the cases, is that a lot of our cases under Chevron and our deference, which are two types of judicial deference to administrative agencies, don't even have the agency as one of the parties in the case, but often they are involved at least at the Supreme Court level with an amicus brief. And sometimes the Supreme Court has actually solicited a brief from the government about the deference issue. So here we go. There's a National Bank Act, and Section 85 of that act, it was passed in 1864, says that a national bank may charge loan customers interest at the rate allowed by the laws of the state where the bank is located. So way back in 1978, long before this case, the Supreme Court had held that this language means that this provision allows a bank to charge out-of-state credit card holders an interest rate allowed by the bank's home state. And if you really looked at the caption of the case, you saw this is Citibank, South Dakota, even if that interest rate would be prohibited by the state where the customer actually lives. So, and by the way, that older Supreme Court case does matter and sort of set the trajectory for what the agency is about to do here. So in this case, a California woman was assessed late fees on her credit card payments, and she argued that the fees were unconscionable and basically not allowed under California law, and she brought a suit against Citibank in California state court. And the bank said that in court, the California law shouldn't apply to it because these late fees were interest payments, really, and that those interest payments were permitted under the law of South Dakota, which was the bank's home state. So just as an aside for my students, individual states get to regulate interest rates or what we call usury rates, the maximum interest rates that banks can charge. And some states are more favorable to the banks, and some states are more protective of consumers and have a lower maximum interest rate. And so, unsurprisingly, because banks are allowed to charge whatever their home state would say, banks want to locate in the states that are favorable to banks, like South Dakota in this case. Okay, let's go back to the slides and see what happens when we get to the Supreme Court. Oh, but before we get to the Supreme Court, while this is still pending in California State Court, the agency that regulates the banks and their interest rates, which is a subdivision of the Department of Treasury called the Office of the Comptroller of Currency, or OCC, did notice and comment rulemaking and promulgated a rule that said late fees do count as interest within the meaning of Section 85. And the court held, ultimately, the Supreme Court, that the statutory term interest allows national banks to charge its customers interest at a rate allowed by the laws of the state where the bank is located, consistent with their earlier holdings. And it accepts the interpretation that this encompasses credit card late payment fees. And basically, it gave Chevron deference to the agency here, which is the OCC. And again, not a party to the case, but did file a brief in the case. In other words, the court in this opinion decides that the comptroller's interpretation of the statutory term interest is reasonable. And now, what about Smiley? Smiley had raised kind of three types of arguments. First, remember this statute was passed in 1864, before credit cards were even a thing, 100 years before. And so she's saying it's one thing to defer to an agency's interpretation of a statute when they're closer in time to the Congress's entrustment or addressing that statute to the agency. But this is so far removed that she thinks that she's arguing that Chevron deference shouldn't apply. And then the argument is made that the definition that the OCC is using is simply unreasonable, and therefore the agency should lose. The agency's rules should get no deference under Chevron Step 2. That's a hard argument to win most of the time. We do study a few cases where the court did hold that an agency's interpretation was unreasonable. Most of the time, the agency is going to win on Step 2. Also, she points out that the agency has changed its position over time, which should remind students of some other cases that we study in our course. The problem here, the Supreme Court rejects this point, saying, but the agency had never actually promulgated a regulation through notice and comment about this issue. It had maybe taken the position in litigation a few times, or filed briefs, or put out informal guidance documents, things like that, but none of those really had the force of law and weren't something that the agency really had to commit itself to. So Justice Scalia wrote the majority opinion in the case, and he has to deal with this difficult question about preemption and Chevron deference. And remember that generally the Supreme Court uses a presumption against preemption. They don't want to apply preemption and preempt state law unless it's really clear in the statute or there's no other way around it. So here, Scalia's way around it is to say that this is not about whether Congress was trying to preempt a particular type of state law and where we would apply the presumption against preemption. Instead, he says here, it's an agency interpretation about how broad a statutory term is, and that happens to have preemptive effect because some states out there had passed laws that kind of were in conflict with this. So he draws a distinction between these cases that involve the breadth of a statutory term and how far we're going to stretch that versus the preemptive effect of the statute overall. So we have some unanswered questions in this case. The case definitely leaves unanswered the question of what our rule is going to be from now on about the presumption against preemption and Chevron, which wins out. Should one take precedence over the other? This is still a live question even after Smiley, because this opinion leaves open the question of whether the agency would get deference on the existence of preemption. Some cases after this one have even treated the question of whether the agency gets Chevron deference on the meaning of substantive terms as unsettled. And so here, the dispute would likely reduce to a clash over institutional values. One could also regard the question here as a clash between two presumptions, right? Or which, in a sense, one could argue are really legal fictions, regarding congressional intent. So maybe some commentators see the presumption against preemption and Chevron as really kind of beliefs or legal fictions about congressional intent that the court uses for the sake of convenience. And so maybe on the one hand, we assume that a presumption that Congress most of the time doesn't want to preempt state law. And then maybe Chevron is a presumption that Congress generally wants the responsible administrative agency to resolve statutory ambiguities. So I don't have a review question for this case, actually, because even though the holding is clear for these parties, our kind of big picture black letter law was left still pretty unsettled by this case. And that concludes our lecture about Smiley versus Citibank.